Hello and welcome. I'm Padmini Dhruvraj from the New Indian Express and you're watching Business Unboxed, where we take the hottest topics from finance, economy, business and break it down to you. So if you're a founder, a venture capitalist or an investor in Indian startups, something important just changed. The Supreme Court of India has ruled against Tiger Global's Mauritius structure and denied tax treaty benefits. The key message is simple: a piece of paper is no longer enough. It means that just because an entity is registered in Mauritius or Singapore does not mean it automatically gets tax protection. If that entity exists primarily to save taxes, the authorities can disregard it. This is what the court called substance over form. The legal case may be over, but the real impact starts now on fund structures, valuations and exits. So let's start with the fund structures. For decades, Mauritius, Singapore were the default routes into India: clean, predictable and tax efficient. This ruling cracks that comfort. The Supreme Court has made it clear that the general anti-avoidance rule can override even old grandfathered investments if they lack real commercial substance, that include investments made even before 2017. So the VC and PE funds are now re-examining these structures. This could mean that some funds will add real substance and others will avoid offshore layers altogether and invest directly into Indian entities. So in short, structures built for convenience are being replaced by structures built to survive scrutiny. Now let's talk about valuations, and this is where it starts to hurt. This ruling does not stop money from coming into India, but it changes how risk is priced. When treaty protection is uncertain, India's capital gains tax, roughly around 12.5% on long-term gains and 20% on short-term gains, suddenly matters. So exit pricing is being recalibrated, especially in late stage and secondary deals. This would mean that the buyers will be more cautious and investors more conservative. Additionally, headline exit numbers may come down, entry-level valuations may come down too. So the old habit of ignoring tax risk and assuming a clean exit is fading. Valuations are no longer just about growth and optimism, they are about what survives after tax. And now the part where the founders feel the most is the exit. This is where the theory becomes painfully real. Three changes are already becoming standard. First, withholding. Investors are holding back a portion of exit proceeds to cover future tax risk. Second is escrow. Money that once hit your bank account immediately is now parked aside for years, just in case the tax department shows up later. And the third is term sheets are getting tougher. Investors want it clearly written who pays if a tax issue arises, and more often than not, that finger points at the founder or the company. So the combined effect is simple: exit takes longer, due diligence goes deeper. So the Supreme Court has clearly signaled that the era of easy tax planning is over. Yes, there will be short-term uncertainty, but long-term this pushes the ecosystem towards clearer, simpler structures. So what do you think about this new regime? Let us know in the comments below. Thank you for watching.